So we are on the second section of Section 10, and we're dealing with some family law issues with respect to various matters, more oftentimes handled in the probate court. The last case was a wrongful birth case, which would have been in the Superior Court. But now we turn to some other issues that sometimes come up in family law and the like. And what this, the Mark versus Kahn case, was kind of an interesting twist on a situation where the wife, or the ex-wife at this point, had been remarried, and she wanted to register their children from a prior marriage under her new surname. And the husband, or the former husband, opposed that because he believed that he was instrumental in helping those children be who they are, that as he saw it, his name was important to their name, and that was the name they were born with. And he wants to continue to have them be called by their given birth name, despite the ex-wife's desire now to blend her new family and to have all of her children, both the children from her first marriage as well as her new husband's children, all have the same name. And the question becomes, does the former husband have any rights to prevent that name change, and how would the probate court deal with it? And so at this point, there are 5 children from this new household, and some of them attend the same school. Some of them have decided that they would like to, or at least the parents have decided that they would like them all to have the same name so that they can be the new Brady Bunch, so to speak. But the former husband says that this is not a good deal. The children shouldn't be not even forced or compelled, but allowed, in essence, to change the name, because he believes that his name is part of their heritage, and since he is, as he sees it, being a good dad, this is just maybe in part for spite, maybe in part it is, or maybe entirely it is well-intentioned. But at the end of the day, shouldn't the biological father, who was married to the mother at the time, have some say as to whether those children's names are changed, especially where he now has strenuous objections to it? And so could it be granted over his objection is the question. And so as we look at the case, what we're looking at is an equitable petition where the court, in appropriate circumstances, has the power virtually to do whatever it wants. But the question really becomes then, would this be in the best interest of the children? And certainly if it's done for spite, or if it's done for reasons that would indicate the idea is just to punish the former spouse, then the court would never, under those circumstances, likely change the children's name. But there may be here legitimate reasons, as the wife is saying, that she wants to have this new blended family be able to move forward together and proceed as one, as opposed to multiple different units that all just happen to live under the same house. The question is, does he have a right to be heard? Could they allow this petition even over his objection? Yes, he does have a right to be heard. He's an active and involved parent, but the fact is that the name still would be up to the court's discretion as to whether they think it would be in the children's best interest to pursue a name change here. And the fact is that anyone can pursue a name change through the probate court for whatever purpose they might desire. If you're an individual and you want to have your name changed, even without a court proceeding, hey, Ray, the law is that you can call yourself whatever it is you want as long as it's not for an improper purpose, even without the court approval. Here, however, they want the court approval. And so he wants the right to be heard. I'm sure he would like a veto power over that, but he doesn't have the ability to have the veto power. But the court has to really take a much harder look at it, as this court sees it, as to what the children's interest is here, what they may want to do, what the spouse's motivation is a factor, but not a dispositive factor. The most important factor is what is in the children's best interest, and would the name change fall within that? The fact is, whether we like it or not, our former spouses can change our children's names over our objection. But if it's motivated for improper purposes, the likelihood of such a petition being allowed is low. I wonder to some extent whether time has sort of overtaken this case. You know, at one point in time, everyone was presumed, 56, so it's as old as I am. That a single name was best for the family unit. But if you think about the things these days, oftentimes mom and dad don't necessarily have the same name. The children can be like this, a blended family, so they're still a family even though their last names may be different. And so I wonder to what extent it would be as important now to change the children's names, or to the motivation that you don't want the children to stand out in grammar school, high school, wherever, because their name is different than mom or dad. I'm just not sure that the times haven't changed that, where it really is pretty irrelevant what children's last names are. And I could see situations that the father is worried about here, where the former spouse simply wants to be a little vindictive and change the children's name, knowing that would drive a lot of people batshit crazy. And so I think the court has to carefully examine what the purposes are, but at the end of the day, there could be reasons why it would be in the best interest of the child. And especially, and it may not be a legitimate factor, but I think the courts do look at it and would look at it, if the father that is objecting, the biological father, isn't an active or involved father, then even though he may get the chance to be heard, his voice will carry far less weight. A lot of times, though, in situations like this, I think you'd have a difficult time where he really does have an interest and wants to be heard. But again, I don't know to what extent it's as important as at one time would have been considered to be, that everyone have the same name. Just doesn't happen all that often anymore for whatever reason. Knighton versus Knighton. And this is an important case because it's an old case, but there's a classic equitable principle at work here that we should be aware of. And what it says is that ordinarily equity will not enjoin the commission of a crime. And so you need to remember that premise, because as a general matter, if we're going in to seek an injunction of some sort, the first rule is that you have to show no adequate remedy at law. Well, if in fact there are criminal violations that are taking place, then there is a remedy at law. The remedy is to seek to get the criminal courts involved and pursue that type of resolution. So trying to get to an injunction when there are criminal activities at work, the first line of defense is just what happens here, is the argument is that you do have an adequate remedy at law. If in fact there's criminal violations, then those should be pursued criminally. The fact is, this principle, equity will not ordinarily enjoin the commission of a crime originates from the fact that, well, then you have a legal remedy. And here it's kind of an unusual case, and again, well, I don't know whether, I think time has also moved past this case. So Mrs. Knighton wants to prevent Mr. Knighton from seeing his girlfriend of long duration because she still wants to stay married to him, and that obviously to the extent he and his girlfriend are stepping out on her, that weakens their relationship, and in part, as she would see it, impairs her marriage contract. And so what she has, instead of taking matters into her own hands, she has decided to bring a suit in equity to now enjoin her husband and his partner, or his girlfriend, call it, from seeing each other because she prefers to stay married to him and continue their marriage contract. She feels, and I don't think it's even disputed, that he is living in adultery, and for whatever reason, the language says he is wholly unable to extricate himself from the subtle entanglement of Mrs. Meadows' charms. Nice way to say it, but the bottom line is she wants an injunction to prevent him from seeing her, and that she has gone to court to try and get that. So what we're asking the court to do here is issue this injunction, but the problem, as we said, is that we're not protecting property rights. What we're trying to do is protect, in essence, the marriage contract, but does she have an adequate remedy at law with respect to, could she attempt to have someone, could she get down to the clerk's office and try to swear out criminal charges? The answer is yes. At this point in time, in this jurisdiction, adultery is a crime. Adultery is still a crime in Massachusetts. Trying to get someone to enforce the crime is rather difficult, but from time to time, you do see it come up. I can't remember the last time I saw it reported. It might have been about 3 or 4 years ago, but the legislature has not seen it in its wisdom to remove it from the criminal offenses, so it's still there. And I do think that as a practical matter, you'd have a tough time selling a court on issuing an injunction of this sort, and especially because you, first of all, can't get past the long-standing tenet of equitable principles, which says equity can't enjoin the commission, won't enjoin the commission of a crime. Let me ask you this in a slightly different context then. So we've got a case and it says they can't, but when we're talking about, like we did in the last case, where the probate court is looking at the best interests of the children and all, could the court, while a divorce is pending, and sometimes they're pending for 2 years, 3 years, whatever, could I seek an order preventing you, the defendant, from having unrelated women in the house while my children are present? Could I get, it's not an injunction per se, but it's an order that would carry with it the threat of contempt, so it may well be equivalent to it. Could you seek, and could I obtain an order while the divorce is pending, preventing you from having unrelated people overnight in the house? What do you think of that?
And it's both of their kids?
It's our, yeah, I've got minor children that are our children. You have custody on the weekends, or you have, whatever. You have custody on the weekends, I have custody in the week. I want an order. It doesn't make a difference whether it's mom or dad that seeks it, but I want an order preventing you from having overnight guests. And what I mean by overnight guests is I don't want your boyfriend or girlfriend staying overnight with my kids in the house.
I'd say not while it's pending.
No, wait a minute, what, I can't get the order I can get it while it's
You
pending,
can't get it until it's final divorce.
but isn't there less reason to get it when it's final and when it's divorced? Then some time has elapsed. I mean, how long are you gonna keep me from sleeping with my girlfriend? Because that's what you're doing, you're saying we can't live together and,
I think the factors as to why you do not want that individual around your child is important. Now, if that individual is a habitual drug user.
no, let's say there's no extraordinary circumstances like that. My argument would be, this is a traumatic event for the children. Mom and dad we're not gonna live all together under our happy little home anymore. Things are gonna change. I at least want for at least while this is pending, which is gonna be some bumps in the road and lots of problems, likely. I don't want them to have to deal with this additional situation as well.
I think that's a fair request, because I've heard parents do that
Oh,
on
yeah.
their own without the court. So I think that's a fair request, because it goes back to the best interest of the child and really not confusing the child as to.
So the
mom
court
and
could
dad, yes.
order that? Would you have a problem? Because here we've got them when they say, well, we're not gonna, and by the way, just like this case, it is adultery until you are divorced. So if you are sleeping with someone who is not your spouse, until you are divorced, that's adultery. So I'm trying to, I could argue I'm trying to prevent the commission of a crime, but what I really don't want is my children exposed to this and have to really try to sort much more complicated things through. So I could get such an order, so in essence, you can't sleep with your girlfriend during the pendency of the divorce? Because part of it, let's be honest, part of it is for spite at this point, right?
Well,
I just don't want her, or I don't want him around my kids. And this is one way to try and accomplish that. But there are legitimate psychological reasons for it, I would think, as well.
Yeah, I could take the adultery argument and further it by saying that, because of this adultery, but for this adultery, it can minimize psychological damage to my kid. My kid can potentially wake up and see my ex or my cheating husband be with his girlfriend.
Right.
Now, my child can think that his girlfriend is, the mother, so to speak, because children are still.
Well, and it may be modeling what one parent thinks is inappropriate behavior to begin with, right? I mean, I'm sure, and again, especially, these are situations where nerves are pretty raw and exposed. And but then the court will unlike Knighton, the court will really involve itself in sort of the personal details of people's lives. And that's premised on the notion that they can do it because it's in the best interest of the children. Is that what you think?
I think that's the right thing to do. Now, on the contrary to that, I think now you're encroaching upon some major public policy issues here now, encroaching upon people's lives and their free will, pretty much.
But we aren't saying you can't sleep with them. We're saying you can't sleep with them while the kids are there, and you can't have them overnight while the kids are there.
That's still encroaching upon their free will.
No doubt about it. Go ahead.
Who's going to determine who's going to find out if I sleep with her?
Oh, they will. Private detectives, they will.
Well, in my bedroom?
You've got a 2-bedroom apartment. The kids are in one, and who's in the other?
Oh, so you're depriving me of my companionship?
Yes, I am.
But you are still married, so technically you have companionship at this time. It's just that you are committing adultery.
You are. And you are potentially, and I'm sure you're potentially causing psychological damage to the children. That's the theory, that's the premise. And part of it is, you know how that works, right? I don't want her with those kids. I don't want him with my kids.
Now, I think that can change a little bit based on the kid's age.
Well, that's fair enough too, isn't it? So if they're younger, it's more likely. If they're older, you think teenagers would be easier to deal with this situation, or I mean, they may police it on their own, but I can tell you that that could be kind of ugly too, right? Because little kids might not know enough to say something sharp, but teenagers,
They know enough.
yeah, no, and they could get ugly. So it may not be wise to do it, but if the teenagers,
I think the teenager brain is more understanding to understand.
right, they could at least articulate to a greater extent their views of how this might impact them, or whether it doesn't really impact them at all because they don't see it as an, whatever.
Right.
But compared to Knighton, the court actually could and in fact does issue orders like that, at least for some period of time, especially early on when that divorce is recently filed and nerves are even rawer. It is not unusual that the court would restrict potentially who can stay in that house, who can be there in front of the kids, and especially as you point out, if there's drug issues, if there is criminal records, so violence issues, things like that, that even more so, it's easier for the court to start to look at what's in the best interest of the children and say, no, clearly being around this or that person isn't in the best interest of the children. And we'll issue orders like that. Again, the probate court, when we're looking at these family law issues, it almost all is going to be governed, like the last case, like this, by this situation, by what's in the best interest of the children. To the extent you can make the argument, for whatever it is you want, that the children's interest will be best served by whatever it is you want, like here, keep the boyfriend, girlfriend away from my children. And not just overnight, they could be away, period. I mean, not yet. Maybe at some point down the road when things are a little better, when you have the kids, she or he can come with you. But at least initially, I've even seen orders issue initially saying not just yet, not just yet. Let's see if we can move this a little further down the road with a little time. And again, partly when you think about some of these cases, in the probate court, you would say, well, I never want to do divorce cases. I never want to do any of that type of work. The fact is there's a lot of work in that area. There's a lot of money to be made because people are fighting about their children and their assets. So they're fighting about the most important things in the world. So there's a lot of work in that area. The problem is you're dealing with people at probably their emotionally lowest point, and you are the most direct contact. So sometimes it can get difficult to be handling every little thing from as they see it, matters of major importance, which at the end of the day are not always legal issues, but psychological issues and things like that, where some of their money, a lot of their money, would be better spent on counselors and really trying to negotiate among themselves than involving the lawyers. The problem is that a lot of clients can't do that. They just, because they're so emotionally invested in the problem, they can't take a step back and be reasonable. And sometimes they will, but it's going to take time to get there. So the early part of these skirmishes are oftentimes can get pretty ugly, and they're not always all that reasonable either.
Would it be your duty to advise your client to say, hey, look, go to counseling?
I think it is. I just think it's good advice to try and make sure that, a lot of times, early on, I would try a fair amount of these cases. And if you've got young kids, especially, I would say to them, listen, you're going to have to work issues like this out for the next 15 years. You don't have the time or the resources to be involving an attorney and running back and forth to court every time you get a problem. You folks need to really try to talk to each other, because at the end of the day, that's what's going to be in the best interest of the kids. They don't need to see you going tooth and nail all the time. And the fact is, the court is going to throw their hands up at some point. The problem is you can say that, you can try and direct them to it, but at the end of the day, there's so much emotion tied up in a lot of it that the message may never be received, even though spending good money on lawyers to fight everything. And some people, at least initially, and sometimes always, will want to fight about everything. Like, you know, I remember, get a call on Thursday at 5. He didn't pick him up at soccer practice. He told me to. Okay, you know, so did you pick him up? You know, I mean, well, I want to go to court. Go for what?
Right.
You know, I mean, stuff happens. And that is, yes, it's a problem. He's irresponsible, but that's probably at least in part why we're getting divorced here, right? I mean, some of the things you can't expect to run to court to solve everything, but the fact is the probate court is there to try and address some of these issues. But I think to the extent that we can counsel them to work out issues, to really talk, and it may take a long while to get there because they oftentimes can't do it early. The fact is that if you're reasonable and you go to court when you have to, when you really have a problem that the parties can't deal with, then the court is likely to look at it a little more seriously than otherwise. Because if you're running to court on everything, your client can't afford to pay for that, and no matter, well, unless they're really rich. But B, you're not going to likely be successful. But nonetheless, there are parties that want to fight about absolutely everything. And this whole bit about who can stay in the house and who can be around them, that's an important thing as people are separating and trying to figure out what they're going to do with the rest of their lives to make sure that they, as they see it, protect their children as best they can, but through to try and get them through the difficult situation. And sometimes counseling will help to a greater extent than that. And, you know, it also might help to provide evidence and information to support why this is a traumatic event and maybe you need to deal with it through the court as well. But it doesn't hurt to try and get them to be reasonable and try to resolve things internally. Let's talk about Edgar versus Edgar because there's a bunch of interesting things going on there that we need to talk about. And this is another contempt coming out of another matter coming out of the probate court. And it was heard before Judge Kopelman. Judge Kopelman is who I tried my very first case before. So this was out in Norfolk. And it's a proceeding for contempt because Mr. Edgar wasn't paying his child support. And so she filed the complaint for contempt. He got notice, and now he's complaining about was the notice sufficient? Did it give him fair warning of what was going on here and the like? Now I want to talk about contempt in both the probate court and superior court so you have an understanding of what it is. Any order that the court issues, so whether it's to pay child support as it is here, or it's an injunction, which is an order of the court, they potentially carries with it the threat of contempt for violation of that court order. And so one remedy, and it's the common remedy for violation of the injunction or violation of the court order here to pay child support, is to bring a contempt action. Contempt actions break down into two different kinds, civil and criminal contempt. And so sometimes, like when they filed this one, was a form complaint for contempt from the probate court. And it says civil/criminal, and they didn't check either, which is not uncommon either. You file a complaint for contempt, the court may well tell you how we're going to deal with it down the road. But I just want to get it moving. So they filed a complaint for contempt. And the difference is between civil and criminal contempt. There's a couple things that you need to think about. For civil contempt, oftentimes the court is trying to coerce compliance with its order. What they would prefer to get done is have the order complied with. So if it's child support, in essence, get him current, okay? If it's an injunction that he can comply with, try to get them to comply. And by the way, you're in contempt if you have the ability to comply and don't. So if he's got no money, legitimately no money, and no ability to earn money, then he doesn't have the ability to comply with the order. The argument would be he's not in willful contempt of the order because he can't comply. Same type of thing with an injunction. But in a civil contempt, the court is trying to coerce compliance. What they want to do is get the person to comply. The argument being in a civil contempt, you have the keys to the jail cell in your own hands because you can comply. Okay? In a criminal contempt, more often it's to vindicate the court's authority. We've found that there's a willful violation of the court order, and now the question is, what should the penalty be? In either case, civil or criminal contempt, the person actually can be incarcerated, can be held until, well, if it's a civil contempt, until they purge themselves of being in violation of the court order, come up with the money or comply with the injunction, tell us where the child is if it's one of these cases where the court has ordered you to disclose the whereabouts of the child. But in a civil contempt, even in a civil contempt, you can be jailed until such time as you comply with the court order. Why? Because the court is trying to coerce compliance. Sometimes it'll be a monetary fine a day until you comply with the court order. In a criminal contempt, it's done to vindicate the court's authority, to punish the disobedience of the order. So you could be jailed for some period of time on a criminal contempt matter because the court feels you had the ability to comply with the order under the circumstances you should have. Having not done, you have violated the terms of that order, and now you're going to be jailed as punishment. Depending on whether it's civil or criminal contempt, there are different protections that attach, just as you would think from knowing the difference between civil and criminal cases. First of all, the one huge difference is the burden of proof, right? In a criminal case, the burden of proof is beyond a reasonable doubt. That's the standard criminal burden of proof. In a civil case, it's a far lower standard of proof. It's simple preponderance of the evidence, right? More likely than not for civil. If it's criminal contempt, you have the right to counsel, court-appointed counsel. Again, I mean, did I say civil or criminal? If it's criminal contempt, you have the right to court-appointed counsel, right? You have your Fifth Amendment right. You have rights that attach to criminal cases. If it's a civil case, you don't have the right to remain silent. You can exercise it since it might lead to criminal cases, to proof of criminal case. However, in a civil case, if you exercise the Fifth Amendment right, it can be commented upon, and it raises a presumption that the answer would be harmful to you. So while you can exercise it, it's almost as good as you giving me the answer in a civil case if you exercise the Fifth Amendment right. And so what happens here in this case is that it's a question of, well, was it a civil or criminal contempt? And this may seem a little hodgepodgey to you, but this is the way oftentimes these cases would have gone in the probate court. So he's in arrears for the order, and he's supposed to be paying $200 a week for support of his minor children. She files the complaint for contempt. So originally, she filed the complaint on October 17th, 86. There was a hearing on November 12th, 86. They figured out how much was owed. There was a judgment for civil contempt on November 17th, 86. So there was a civil contempt attempted first. Then he didn't pay the arrearage. She filed a new complaint for contempt in February 2nd. He appeared on March 5th. He tried to vacate. He filed a motion to vacate that judgment for civil contempt, and the motion was allowed. At that point in time, on March 5th, well, that can't be right, February 2nd, the judge then announced that he had conducted a hearing on the complaint for contempt filed on February 2nd and treated it as a complaint for criminal contempt. So he warned him that if we're going forward, then we're going forward with criminal contempt. He then tells the counsel for the defendant, who I know all of these folks actually, he was a good guy, John Ottenberg. He tells John that if we go forward, your client would be incarcerated if he's found guilty. So he warned him that we're going to go forward, it's going to be criminal contempt, and if I find he's in contempt, he's going to jail. 2 hours later, the hearing commenced. That's a relatively short warning, but it's a warning. Plaintiff's testimony at the time showed the amount of the arrearage. The hearing is then continued just for one more week, so again, he's got some time. Further evidence bearing on the defendant's ability to pay came at the March 2nd. You have an order and you have the ability to comply with the order is what puts you in contempt. At that point, the judge found the defendant guilty and sentenced him to imprisonment for 30 days. So this is not pay up and you're out. This is you are guilty of criminal contempt, you go to jail for 30 days. So he can't even purge himself of his contempt by coming up with whatever the arrears is. And oftentimes in the probate court on the contempt petitions when it's for money in arrears, that's the way it works, is the court says, until you come up with $5,000, you're going to jail. And believe it or not, people oftentimes will come up with the money when faced with that alternative, because they're going to real jail. Like if you leave from Lawrence, you go into the not Middlesex, you're going to Essex County House of Correction over here near the far end of 114. It's a Route 62, it actually is. I mean, with everyone else who's been arrested on much more serious charges, that's where you're going. So there's a real incentive if you're not a criminal to do something to come up with the cash. This guy's a CPA, and I don't know, he might have been a lawyer at this point as well, but he was certainly a CPA. And so spending 30 days for anyone is bad. Spending 30 days, if you're not a tough guy, is incredibly problematic, I would think. At any rate, so he was in fact held from March 12th till April 2nd, and then the balance of the sentence was suspended until further order of the court. I wonder whether it was suspended because he came up with some of the arrears, but it doesn't say that. So now he wants to argue that this was a mistake by the court. He should have been treated to the protections if it's a criminal contempt case, and far more notice that he got, and that he should have got his right to a jury trial. So let's take a look at some of those issues that he's raised. He first wants to say it's a denial of a jury trial if it's a criminal contempt, and that's not appropriate. And then, so look at page 618, which you probably should know from Crim Pro already, but it says there is no constitutional right to a jury trial in a criminal contempt proceeding in which the penalty is 6 months imprisonment or less. So we have sort of a bright line there, that if you can't get more than 6 months, even if it's a criminal contempt situation, the U.S. Constitution does not guarantee you, nor does our Constitution, guarantee you the right to a jury trial. So he may want it, but the fact is he doesn't get it. While he might like the jury trial, he doesn't have the opportunity. And look at the difference here. It says, if the defendant's case had arisen in the Superior Court, he would have the right to a jury trial. However, the probate courts have no such provision. So if you were going on a criminal contempt, on an injunction, most injunctions in Massachusetts are issued in the Superior Court, then he would have had, even if it's 6 months or less, he would have had the right to a jury trial, because the probate court actually is physically incapable of having jury trials. The courtrooms aren't set up for that. Then he doesn't have any right statutorily or under the Constitution, so he's out on that argument. So there is a distinction as to what court he's in with respect to that. And so he had counsel. It wasn't appointed, but he had private counsel, so he doesn't raise that issue. But he would have, had he not had counsel, he would have had the ability to have counsel appointed. But the fact is that he is in the probate court, and the probate court has no ability to offer a jury trial. It's not required when the penalty is 6 months or less. I want to ask you a question about, there's a note at the end of this, that it says probate courts have exclusive original jurisdiction of actions for divorce or for affirming or annulling a marriage, and then it makes reference to General Laws 215, Section 3. What's that mean now? What does that mean? Exclusive original jurisdiction of actions for divorce. What's that mean?
Only the probate court can hear.
Only probate court in Massachusetts can hear it. At one point, Superior Court could hear them as well. But now, if you're looking for a divorce, or you're bringing a petition to affirm or annul a marriage, the only place you can go, and you better be there, is in the probate court in Massachusetts.
So wait, when I think of probate, I think of testacies and wills and stuff. So is family court part of probate?
Yep.
Okay.
Yep. Yeah. It's called probate and family court,
Oh,
and
right.
and I'll.
PNF.
Well, I never called it that, but yeah,
They
it's,
don't
it,
really label it on the
it could be because that's what the letters are. I actually would bet if we looked at the numbers, it's far more family court than probate. I'll check on that for you, but divorces is what its life's work is. Support petitions, you see that as well with respect to child support not being paid. You have a lot of trust and estate work there, but I guarantee the bulk of the time is on divorces, adoptions, well, even adoptions less so, but divorces and the like, and the contempts and things. But now that I wonder what the distribution actually is, but that's my feel. But I haven't been in the probate court in a while, but my wife is. I'll ask on that because I know from a standpoint of hearings and proceedings before the court, if I had to guess, 75, maybe more, north of 75% is all family cases. But there are a fair amount of trust works and estates and things like that as well. But I think it's really a relatively small percentage of the filings. But actually, I wonder what the answer is. But anyway, that's where you're going to go. You have another Edgar case that I just want to make reference to as well, because this is important to understand. So there's a second case here where he's then found in contempt. He then takes it on appeal. So he's got two cases here, and if you look at it, see, this is what aggravates me about some of these cases. So this one is 403 Mass 616. That's a site that means the Supreme Judicial Court of the Commonwealth of Massachusetts heard this case, and that's the first decision. And now the second one is 406 Mass 628. So then the Supreme Court heard it again, or heard another appeal from this case. He's in court for not paying child support. You should direct him that instead of wasting his money on taking these foolish appeals, he should be paying child support. That should be his first GD obligation. And it's amazing how people get so invested emotionally that they will spend a fortune on things that it would be far more productive to put them to use where they're needed. Pay the child support or pay a portion of it. You know, go in for a modification if you can't pay it all, but do something with it. Instead, he takes two appeals, and he's a CPA, he's a smart guy. He takes two appeals to the Supreme Court, cha-ching, cha-ching, cha-ching. This is ridiculously expensive. And by the way, both of these lawyers, I know them both, neither of them are cheap. So you've got Jim Krasno and John Ottenberg charging a fortune throughout these cases, and the kids aren't getting their child support, but the lawyers' kids are eating. It's to me, it always was a sort of a frustrating part. I had clients like this too, is that to try and redirect their efforts and channel them, it's just very exacerbating sometimes that you can't talk sense to some people at times. So anyway, look. So what he does now is he brings another appeal to the court, and again over the arrears plus attorney's fees. So that's the first thing I want to make I wanted to make mention of. When you're in contempt, or when you seek a contempt petition, one of the remedies is that I'm entitled to my attorney's fees for pursuing the contempt petition and winning. Okay? So one of the damages, one of the things you're going to owe is the attorney's fees to the other side. So another reason to counsel your client to stay away from being in contempt, because as we've said before, general matter, each party pays their own attorney's fees. not in a contempt petition. If you're in violation of that order, and he or she had to pursue contempt proceedings, you owe the cost of pursuing those contempt proceedings, not just the filing fees, but the lawyer's costs. And again, in a case like this, it can turn into a lot of money.
So that applies to a criminal contempt?
Even a criminal contempt in the probate or the Superior Court, the answer is yes. That the court, you can petition the court for those fees as well. And so in part, that's what we're looking at here. So they're looking for,
So would you petition the same probate court for those fees in the criminal?
yeah, but the same court, same judge, so it really is, and that's the other thing I meant to mention here when we looked at some of those times. This is quick, right? Those hearings, the filing was 1 month, the hearing is the next month. These are relatively speedy proceedings. So there's not gonna be a lot of time spent, on all the discovery and everything else. There can be some. But the fact is, the court wants you to comply with the order, so the speed with which some of this is going to go is going to be quick. Another reason to try to talk to your client and direct them to do the right thing with respect to these orders. If they can't comply with the order, then you need to go in and try to modify it. If they can't comply with the injunction, you got to go in and try to get it set aside. Because beyond that, we should be counseling them that they've got to comply. Otherwise, they're going to go to jail potentially. And it's not uncommon, and especially with some judges, they are going to see it as an affront to their authority. They waited carefully, they told you what to do. If you don't do it, unless you want anarchy, there's got to be some penalty for doing it. And there are many judges who have no problem making sure that their authority is well understood. And so this would be likely the case. So at any rate, the plaintiff now is seeking attorney's fees, and as I just told you, that's part of the game. That's part of the price you pay if you're in contempt. And so they awarded counsel fees in the amount of $26.45, and he takes another appeal saying I shouldn't have to pay. So he says this violates a number of federal and state constitutional rights. The court says, listen, we don't really care what you have to say in that regard because you didn't object originally. The fact is, these are reasonable attorney's fees and expenses related to the attempted resolution of this matter and the prosecution of the contempt. They are going to include reasonable attorney's fees. And now, to add further pain to his case, if you, in bad faith, pursue an appeal, the court can also tax you the cost of that appeal. And that's what's happening here as well, is not only are you going to have to pay those fees from the other case that the court awarded, but we don't think that this appeal is brought in good faith, having continued to use what the court sees as dilatory reasons, then not only are you going to have to pay those fees, but you're going to have to pay the fees for the cost of bringing this appeal. And again, it's the thing I was trying to explain to you is that his counsel should have, and may well have, tried to direct him to use his resources and efforts to a greater extent to comply with the order. And the fact is that whether he was given that advice and chose not to do it, or never got that advice, which I don't think is likely knowing the lawyers involved, the fact is that at some point the court's going to call an end to it, and you're going to end up owing potentially even more than you owed before, because of the way we can shift costs for things like this. And that's precisely what the court ultimately does. Now last, I've given you a couple articles about thinking about some of the emotional issues and psychological issues that are involved in some of these areas, whether it's, the run-of-the-mill support issues, or it's who's getting to stay, or what their name is going to be, and who can direct their religious upbringing and the like. But the fact is that the probate court has vast amounts of discretion to try and shape relief here. And it should really start with you having a discussion with your client about being reasonable about what the ask is. The fact is that it's a lot harder to say no if what you're asking for are reasonable things. To the extent you're running in and out of court every week and you're not really focusing on what's in the best interest of the children, at some point you're not going to be taken seriously by the court at that point. And to some extent, to the extent that I know I am not a good counselor. I know some lawyers are much better at that. We have a collaborative law that they do a lot with now, and where they try to work together to try and resolve some of these issues with the lawyer as sort of the peacemaker. But if you're not equipped to do those things, then we got to get them to someone who can help them as a counselor. Family counseling is important through this, and to me, it may well be a lot better use of their time and money than giving, $300 to us to be running in and out of court, because the judges aren't well equipped to resolve it either, and neither are the probation officers on some of these issues. At some point, as I said to you, when you're looking at relatively young parents with relatively young kids, there's going to be a period of 15 years going forward here, at least, where you're going to have interaction with each other. It's easier said than done, but to the extent that they get that message and really start to think about using the resources to raise their family and their children, makes far more sense than throwing fistfuls of money at us. Because that's, some of these cases will take tens of thousands of dollars to litigate, and not necessarily be any further down the road for it. They might have a resolution, but the problems are going to continue. So, a lot of cases, a lot of interesting issues that come up in the family law area. Shift to damages next time we meet.
So you mentioned being reasonable with your request for
Yeah.
yourself, right? Where is that line between being reasonable and shooting yourself in the foot?
Oh yeah, I would never say, I'm not saying roll over and play dead or take less than what you're likely to get. And I think a lot of times the financial issues are a lot easier to see and to be able to know exactly, not exactly, but within a range, what would be a reasonable resolution of there for the length of the marriage and how those assets were accumulated and all of that. I think the financial part of it sometimes is a lot easier than some of these other issues with the children and custody and, summer camp and the cost of some of those things. That gets a lot harder for people to separate out the overnight guest issues. But those things, to me, the first set of financial issues, those are CPA and lawyers. We can figure out not exactly, but roughly what the court is likely to happen there, give or take a range. On some of these others, you got to know more the family dynamic, the children's heads, where they're at, and all the rest. And I don't think we're necessarily well equipped, sometimes I'm not, to actually give them direction in that regard as to what is best for their own children or what is best for the two warring spouses. What I found early on, and because I did these early on, is that oftentimes there was no reason. People just couldn't listen, and maybe in a year and a half down the road they'll listen better. But the anger and the hurt is so much that to try and get to the point where, okay, let's put all of that over there and let's really figure out what we can think is the best interest here. That's hard to get, and that's the problem. Is it's hard to tell them. I can tell them, well, listen, unless there are issues, drugs or violence or things, there's going to be a shared custody here so what are we thinking we can do on every other weekend, or what about days of the week, and what about midweek visits now? I mean, it's all, and how far apart are they? I mean, that's the other thing, is that the travel and who's going to pick up and who's going to drop off, those are really practical, legitimate issues. But again, you wanted me to be paying $300 an hour to me to try and solve your Uber issues. I mean, that seems like there should be something that you both need to be reasonable, but the point is, saying that doesn't make someone reasonable when they're just batshit crazy. And sometimes that's precise, especially early on in the process. It's not reason, it's emotion that controls a lot, and it's anger, and it's hurt, and I get all that, but you know, are we the people best to deal with that? So,
I just see it as from a financial standpoint, there's always those men not married to a woman that feels as though that woman and that man is like making a lot of money, so to speak, a breadwinner, and you know, he feels as though that woman is only doing all this to make money, you know.
oh yeah, well,
So, you know, it's just like thinking about it.
it's on both sides, a feeling that you've been taken advantage of and that it's unfair. The problem from child support, though, child support is pretty much, it's a mathematical formula for the most part. Now, there's always other things and tons of things that happen down the road, summer camps, you name it. But the child support, and the child support is significant. So when you talk about making money, on some of these cases, there's going to be a big orders made with respect to child support as well. But again, that tends to fall a little more mathematically. I'll see you guys.